Thank you, Madam President. I rise to oppose this legislation. On its face, it may seem like a pretty innocuous piece of legislation, but I think when you put it in the context of how you actually prosecute a crime in this state in our courts, you see the problem that I think will occur if enacted. Let's understand why and when and under which circumstances bail is set. When someone is arrested for a serious crime, a felony in this state, there's an arraignment. And at that arraignment, the prosecutor makes a bail application. The defendant has an opportunity to be heard. A judge reviews the arguments, looks at the defendant's past history, if there is one, the defendant's rap sheet, and sets bail only if it is determined that the defendant, who is charged with a felony, a serious crime, presents a flight risk. That's why we have bail set. There's due process. It occurs at the arraignment. The rap sheet is looked at. Perhaps we have a defendant who has committed crimes in the past, who has not shown up to court. There are bench warrants issued. All that is considered, and in the interest of protecting the people and the process, bail is only set when the court decides that this defendant cannot be trusted to return to court during the pendency of the prosecution. And it works most of the time. Could you imagine if, in the Bernie Madoff case, you had bail set because, given the circumstances of the case, you're not supposed to actually consider the underlying crime, whether it's murder or burglary or robbery. But in fact, as a matter of practice, it is factored in, the theory being that the more serious the crime, the more serious the ultimate potential penalty, the higher the flight risk is presented. So could you imagine in the case of Bernie Madoff, when all that money is being stolen, when you have a person of means who could hop on a plane and go anywhere he wants if he so chooses to avoid and evade justice? Could you imagine that bail being set in that case after 45 days for no reason except that 45 days have passed, that all of a sudden, automatically, bail is exonerated? Do you think Bernie Madoff would continue to come to court? Or do you think he would take off on a plane and go to the corners of the earth and evade justice? Of course that's what Bernie Madoff would do. Now you might say, well, that's a white-collar crime. It only involved the bilking of Americans and their financial circumstances. But the same would occur in serious cases of rape and murder, burglary, robbery. It is bail that, in many cases, keeps a defendant returning to court to face justice. Remember, this is a defendant who is not in jail. Their liberty is not being denied at this point. They're free to come and go in most cases, but they must return to court. And it's because they have bail hanging over their heads. It's been said that this is so that we could shift the burden to the prosecution. The burden is already there. The people, the prosecutors who represent the people, they already have the burden of making the argument for bail. And if there are truly changed circumstances within those 45 days, and going back to the Bernie Madoff case, very complicated case. There's a reason why you might not have an indictment in 45 days. You need to marshal the evidence, speak to the witnesses. Very complicated case. To force the prosecution to rush to the grand jury to seek an indictment simply to avoid having the defendant released, which would happen in this, under this legislation, would not, I think, be consistent with the administration of justice in this state. But in the case where I think the sponsor of the bill, I think, is focusing on the fact that perhaps after 45 days we don't have an indictment. Perhaps it means that the prosecution really doesn't have a good case, or is sitting on their hands, or is not really doing their job properly on behalf of the people, or that something has changed with respect to new evidence that suggests that maybe this is a case that we will not have an indictment within the statutory 30-30 speedy trial time, 6 months, by the way, as has been said. Well, then the system already allows for the defendant to appear before the court under the present law and make a new application and present that argument. And it occurs all the time in this state. If that is really what has occurred, we have those changed circumstances, that argument can be made right now. And quite often, a judge will look at that new evidence, those changed circumstances, and sometimes the prosecutor even agrees and removes or agrees with bail being lifted. And the case continues until and if there's an indictment. So we have the ability to do that under the present law. There's another issue here, and it's cost. By setting an arbitrary date of 45 days, again, there's no rhyme or reason to why we're selecting 45 days as the time in which a prosecutor must bring an indictment or else bail is going to be exonerated. That would mean that we'd have to have another forced court date, 45 days after the arraignment of every felony case in this state, which would mean you'd have to bring the defendant back, you'd have to bring the people back, the defense attorney back, often legal aid or court appointed. You'd have to have yet another case put on the calendar in our already clogged criminal justice system. And we're not talking about a few. We're talking about thousands, tens of thousands of new court dates that will have to result because of this legislation. I don't see a fiscal statement, but I can tell you the cost to this state will be enormous. Will be enormous, simply because we're going to have to drag people back to court so that we could automatically remove bail. I think when you look at this piece of legislation, which I believe will result in more bench warrants being ordered, more felons evading justice, more defendants not returning to court. I think when you put this in the context of the legislation which reduced the sentences on many very serious drug crimes in this state, when you put it in the context together with that, with the downturn in the economy, and with some of the other measures I've seen pass the Assembly already and maybe coming before this House, I believe that together they represent the gathering storm clouds of a new crime wave in this state. And I think it's something that we need to be very, very mindful of. There's a reason why bail is set on very serious felony cases. I know one of the arguments with respect to why 45 days is that because in the law as it exists today, if you're incarcerated, if your liberty has been taken from you during the pendency of a felony case, where you haven't either made bail or you were held without bail because of the serious risk of flight that you presented, that if a DA's office, if the prosecutor doesn't bring an indictment within 45 days, you're released. That makes more sense. Your liberty has been taken, you're incarcerated. I think under those circumstances, everyone agrees that we might want to put an extra burden on the people to make it, give an extra incentive to the prosecutor to bring that indictment. And if you haven't done that in 45 days, then I think we can all agree that it does make sense that at that point you ought to be released. But that, I don't think, is the right analogy with respect to what's happening here. In these cases, defendants are already out. They're not incarcerated. It is the bail which is set in order to provide an incentive to have them return to court. I think by just automatically and arbitrarily removing that bail will result in many, many felons in this state evading justice, and that's why I oppose this legislation, Madam President.